socio-economic and political arena worldwide, administering alternative dispute resolution mechanism with institutional framework along with long-term capacity building programs seen globally. So it has become imminent that conflict resolution has to be facilitated by dialogue with long-term focus by way of good communication platform and acceptable dispute resolution mechanisms, adopting global standards. The essentiality can be cornered down to basic research and promoting institutionalization of ADR with state-of-art infrastructure, tailor-made rules, regulations, and execution with diversified trained professionals. In order to cater for such allied needs, KFCRI provides to set up a center for aid, arbitration, conciliation, mediation, negotiation, with a special focus on mobilizing ADR practitioners and tribunal secretaries. So now I am here to give an introduction about Ms. Samina Syed. So Ms. Samina Syed is an Indian enrolled lawyer and accredited arbitration practitioner who hails from the southern part of India. And she holds a bachelor degree of law, BA LLB honors from the Tamil Nadu Dr. Ambedkar Law University, School of Excellence in Law. She also holds a master's in international investment treaty arbitration with a distinction from Uppsala University, Sweden, wherein she was recognized as a top performing candidate of her class. And she was the first Tamil Indian law student to have graduated from this master's program. And she currently holds the position of associate at KFCRI, wherein she undertakes and leads their sector-specific project in investment treaty arbitration. Furthermore, she is also an associate to international arbitrator Mr. V. Invocation, wherein she upholds the responsibility of taking care of his international arbitration practice, as well as access and tribunal secretary. So now over to you, Ms. Samina.
Thank you for a very kind introduction, Amina. Thank you so very much, everyone. It's a pleasure to meet you all again after a wonderful training session that we had in the month of January. Just as a context, I will be talking about one of the emerging trends that's currently happening in India, which is making India more arbitration-friendly regime to not only domestic arbitrations moving forward, but also to international arbitration. Just to explain it further, I would like to talk about the emergency arbitration regime in India. Just a moment. I think there's a technical glitch. If the host can enable screen sharing, that would be great. If that's okay. I think that's disabled. Okay, until and unless that is sorted, I would like to continue with my talk. Emergency arbitration is a concept that is booming not only in India, but we see it as a growing regime across jurisdiction. It is not a new concept as such. It's been in existence, but it became a very cultivating trend only as a procedure or a mannerism of expedited arbitration. So when I say emergency arbitration, the one question that would pop in everybody's mind would be, what is an emergency arbitration? An emergency arbitration is nothing but a arbitration proceeding or a arbitration mechanism that or a tribunal which would be constituted prior or before the constitution of an actual arbitration tribunal, which will enable parties to get their reliefs resorted, which is basically would be interim reliefs of any nature. So usually emergency arbitrations are enabled by institutional rules. For example, KFCRI is yet to get into, okay, one second. If all of you can see my screen. So emergency arbitration, as I mentioned, is nothing but a trend that has been evolving in the current circumstances. And it is nothing but provided by an institutional rules, enabling parties to get interim measures resorted by way of institutionalized rules. And legally speaking, or very technically put, both in theory as well as in practice, parties to an arbitration proceedings will opt for emergency arbitration if they have any interim reliefs to be sought in order to protect something that is very important, very vital to the subject matter of the dispute. For example, there are several institutions across the globe introducing emergency arbitration or do have emergency arbitration under their umbrella. KFCRI also has one, which will be released very soon. Just as an example, I would also like to talk about SCC arbitration, which is highlighted on the screen. They have an emergency arbitration process as well, and including the ICC. So this is not something new. This has been across, or this has been celebrated across the globe, and is also seeing a very much booming effect in India. So when I say emergency arbitration, as I explained before, it is an arbitration tribunal constituted prior to the actual arbitration tribunal, who will sit and hear urgent and necessary claims alone or interim reliefs. So a question again would pop in mind that what will determine the jurisdiction, because jurisdiction is one important concept in dispute resolution as such. So an emergency arbitration tribunal will only hear application which portrays urgency, matter of urgency and necessity in need, which has an element of risk involved. And in an application for emergency arbitration, a party must always show the proportionality of the measures sought and a reasonable possibility of success in the merit claim. So only if these are satisfied, then an emergency arbitration application will be accepted by the tribunal, and subsequently the emergency arbitration will take place. This is not a jacket line definition for jurisdiction, but however, in the practice in international arbitration or domestic arbitration across the world, this has been an accepted mandate on how an emergency arbitration application must be accepted. So in general, the procedure is very simple, and it also is it looks alike like a normal arbitration procedure. That is, if any party has a claim or if they want an emergency need to be resorted, first they submit an application of an emergency arbitration to the institution that they required to move in, and then an emergency arbitrator is appointed in some cases within 24 hours or maximum within 2 days, and then her hearing is constituted. Usually the rules mandate for how long the hearing shall go through. If we look into institutions that are currently present across the globe, hearings range from 5 to 15 days, and that's all. The hearing ends there, and then an award or a decision is given. An award or decision becomes very crucial at this point, because this is what determines what might happen next. But an interesting theory that comes into light is interim reliefs is not something that can be only granted by the emergency tribunals. Courts can also come into picture in granting emergency reliefs. For example, if we look into our Indian Arbitration Act, for example, Section 9 talks about interim reliefs by the courts. If you read the legislative mandate, it's a wider scope, giving wider ambit for the courts to step in and to get it's easier for a party to get an interim measure by the courts, because it's automatically binding between the parties, just like how we studied during our training processes, that it's easier to get it enforced. But when you go into a mannerism of emergency arbitration, again the legislative mandate will follow, and then the enforcement proceedings will happen. But when we look or read more into our law, that is the Indian Arbitration Act, there is no specification of what will happen to a decision rendered by an emergency arbitrator or an emergency arbitration tribunal, or the nature of the award or a decision that is given. Even if you look into Section 17, which talks about the interim relief given by the arbitral tribunal, or arbitral tribunal does does not have the scope of emergency arbitrator. That is, the meaning does not, arbitration tribunal meaning does not also hold emergency arbitrator or emergency arbitration tribunal. So this is a conundrum that we see currently in jurisprudence. So now when we look at a bigger picture or a whole concept, when it comes to enforcement of any award, two things come into play. That is lex arbitri, which is the law of arbitration in a particular country. In India, it will be the Indian Arbitration Act. And then comes the New York Convention, to which India is a party to. So when we take such two things together and we observe, our Indian Arbitration Act is completely silent on emergency arbitration in general. For example, the act does not mention if there is a relief can be given by the emergency arbitrator, or the definition of arbitration tribunal in the definition section of the Indian Arbitration Act do not specify emergency arbitrators. So in that case, our Indian law is completely silent on emergency arbitration or the enforcement. And when we look into New York Convention allows and by mandate of its rules and regulation, an award can be enforced only when it's a final in nature. So when all of this is happening and then an emergency award comes, one most pertinent legal question that would arise anytime is that, are emergency arbitration awards enforceable and considered binding upon the parties? Because again, the legislation does not mandate anything. And this is the conundrum not only seen in India, but it's been seen across jurisdiction. And what other countries have done is either they have amended their legislation in such a way to include emergency arbitration regime within their national regime, or they've amended their arbitration tribunal definition to include emergency arbitration, or they've prescribed in their legislation, or they've accepted like a precedent or a legal instrument released by the government later on, which confirms the finality given by confirms the finality of a decision rendered by an emergency arbitrator or an emergency arbitration tribunal. So when we see what's happening in the world, and when we observe what's happening in India because of the legislation silence, a new interesting case came into picture a year ago exactly, before the Supreme Court of India, which is known as the Amazon versus the Reliance case. Basically, this case involves completely on emergency enforcement of emergency arbitration award. Amazon invoked an international arbitration using the SIAC rules, which is the Singapore Institute for International Arbitration rules, in using their emergency arbitration provision to get an interim relief against Reliance, as because to protect something which is very, very vital to the dispute at hand. And an emergency arbitrator sat for the proceeding. He gave a decision, and Amazon took that decision and came to the High Court of Delhi and enforcement, because that was the seat of arbitration as well, and also the place for enforcement. Amazon took that judgment or the decision that was given by the emergency arbitrator, came in for enforcement. And once enforcement proceedings started, Delhi High Court rejected it, saying that it's no longer enforceable. Upon this decision, Amazon appealed to the Supreme Court, where a landmark decision on the very concept of emergency arbitration accrued. So basically, the Supreme Court says, we very well recognize the enforcement of emergency arbitration decision or the award given, making India a most friendly arbitration environment henceforth. So they recognize three three things which is very vital and which also contributes to the emerging jurisprudence, not only in theory, but also in practice. They recognize party autonomy, which is one of the vital concepts of arbitration. And they stated that by way of party autonomy, parties can choose to resort to emergency arbitration and can sort interim measures out of it. And thereafter, they stated the meaning, that is 2D, that we just observed minutes ago, includes emergency arbitration, and the arbitration procedure also, the proceedings also mean emergency arbitration proceedings. So by way of all of this, they stated emergency arbitration awards are binding upon the parties, and this establishes as a rule of law moving forward, making India a more arbitration-friendly environment. With this, I would like to conclude my presentation. Thank you so much. If you would like to read more about it, Professor and Arbitrator INVOCATION and I have written an article on it. Feel free to write us an email at kfcri@gmail.com, and we would be happy to send across our literature contribution on it. I would highly request all the participants here to have a vital view or have a very nuanced view on emergency arbitration, as it's a growing and one of the most effective forms of dispute resolution for interim measures. So thank you so much, and over to the organizing MC.
Thank you for your speech on emergency arbitration regime in India, Ms. Samina Sayed. Now, I am delighted to welcome Mr. Shahrukh Kumar to deliver speech on arbitrators' conduct and behavior. He is an advocate practicing predominantly at the Madras High Court and also regularly appears before the district and subordinate courts and other tribunals and commissions in and around the vicinity of Chennai. His practice revolves around civil and commercial litigation, arbitration, criminal trials, etc. He is also an ADR practitioner and one of the managing committee members of KFCRI, who has been part of institution ever since its inception. Shahrukh Kumar has been acted as an arbitrator, mediator, and is currently representing as legal counsel in various arbitration proceedings. He has also acted as tribunal secretary, assisting numerous arbitral tribunals presided by retired judges of the High Court, District Court, etc.
Thank you, Vasan. Thank you, Vasan. Thank you for the intro. So, rather than giving me a fresh introduction, I think all of us have already met and we know each other. And I think this is a very much needed brainstorming session at this point of time, because it is rightly, I think, exactly a period of 2 months have lapsed since the mandatory training program under all of your accreditations for an associated arbitration practice has been completed. So I think it's a much needed session right now. And before I go on to my session, of course, thanks to Samina Sayed, who has given a wonderful talk on emergency arbitration, which is the most welcoming development in the arbitration regime all around the world. So I've been asked today to talk on arbitrators' conduct and behavior. So this is rather a very interesting topic, which I would love to talk about, because when we talk about arbitrators' conduct and behavior, I need not restrict myself to the statute, or rather the rules, and it is more of a practical approach which arbitrators have towards the proceedings. So my experience in arbitration, I've worked with arbitrators both as a tribunal secretary and as a counsel. I've worked with arbitrators from different walks of life, which includes arbitrations presided by retired judges of the High Court, retired judges from the subordinate judiciary, advocates, chartered accountants, and people who are who are completely from a technical background, I had the fortune of working with some of the retired chief engineers from the Tamil Nadu government. So each of these, why I want to tell this is, each of the arbitrator I've worked with, both as a tribunal secretary and a counsel, had a different way of conducting the proceedings. Of course, each of it had its own, novelty. But what was common in everything is what I'm going to talk right now. So when you go to a court, the conduct of a judicial proceeding does not change from court to court. Maybe the approach of the judge or the approach of the judicial officer changes from one court to another, whereas the manner or the procedure in which a judicial proceeding is conducted is not going to change from one court to one court, because the procedure is going to be governed by the procedural law, which is going to be the Code of Civil Procedure or the Code of Criminal Procedure, along with the Evidence Act and other procedural laws. Whereas what is very beautiful in arbitration is, you do not have a pre-codified procedural law to govern the arbitral proceedings. So the parties are at free will to choose their own procedure. So when the procedure is flexible, again, it gives some amount of leverage, or flexibility to the arbitrator to conduct the proceedings in his own way. So talking about the conduct of the proceedings and the behavior of an arbitrator. So as we all know, in India, there is no specific qualification for a person to be an arbitrator. I repeat, there is no specific prescribed qualification for an arbitrator. But that does not mean that an arbitrator need not possess any quality. So you understand the difference between qualification and quality. So when I say qualification, it is not necessary that an arbitrator should possess a degree in law, or it is not necessary that he must be a person who has completed his master's in a particular subject, or it is not even necessary that he is accredited as an arbitrator by an institution. So there is no quality under section 11 of the Arbitration Act. Any person can be an arbitrator. And of course, we in the practical sense, we restrict it to any person who is a major, because when you're going to adjudicate a contract, you firstly have to be eligible to enter into a contract. So in India, the eligibility to enter into a contract is you must have completed 18 years of age. So therefore, the only qualification we see for an arbitrator is that he must be a major person who is eligible to act as an arbitrator. Whereas the Arbitration and Conciliation Act in itself prescribes certain qualities for an arbitrator. Though it does not expressly state that these qualities should be possessed by an arbitrator, when we look into some of the sections under the caption Conduct of Arbitral Proceedings, it is necessary that an arbitrator should firstly be independent and impartial, and secondly, he must be able to devote ample amount of time for the conduct of the arbitral proceedings. So these are two important qualities which are mandatorily to be borne by an arbitrator. Qualities which are mandatorily to be borne by an arbitrator under the Arbitration and Conciliation Act. So interestingly, in the year 2019, the legislation introduced a new amendment to the Arbitration and Conciliation Act under Schedule 8 of the Act. So a new schedule was introduced wherein qualifications were prescribed for arbitrators. So Schedule 8 read as, in order to be qualified to be an arbitrator, a person must possess so and so. So the so and so said he must be an advocate with who has completed 10 years of practice. He must be a chartered accountant. He can be a chartered accountant who has completed 10 years of practice in his accountancy field. And it had few other heads. Along with that, there were also 8 other general norms which were supposed to be followed by the arbitrator. So of course, we know again in the 2021 Amendment Act, the Schedule 8 was scrapped. both the qualifications prescribed as well as the general norms, the 8 general norms which are given to an arbitrator were scrapped because it had much of criticism. If the Schedule 8 was to be followed, then experts in arbitration felt that India's the goal of making India an arbitration hub would not be possible. Not only in the near future, it would not be possible anytime. Because, in fact, the amendment to Schedule 8 said a foreign national cannot preside as an arbitrator in a domestic arbitration. And it was rather mandatory rather than directory. So, of course, in the 2021 Amendment Act, this Schedule 8 was scrapped. So why I'm going into this technicality is there were 8 norms which were prescribed under Schedule 8, which said an arbitrator should be a person possessing knowledge in commercial law. He must be a person who is capable of understanding the nuances of arbitration. He must be a person who has the quality to draft an enforceable arbitral award. These were all, again, qualifications which are not norms. Because, in order to possess all these, you must be qualified in some, through some means. So these were, rather than norms, these were considered as qualifications. But interestingly, there are 2 qualifications which could never be, qualities which could never be compromised in being an arbitrator. Firstly, you have to be independent and impartial. So as we know, though arbitral proceedings are not bound by the Code of Civil Procedure or the Evidence Act, we still do not escape the clutches of principles of natural justice. So as we know, in any proceeding, any judicial or quasi-judicial or adjudicatory proceeding, principles of natural justice is to be followed. So in order to follow the principles of natural justice, an arbitrator should be a person who is both independent and impartial. So when I say independent, he must be independent of the dispute which he is adjudicating. He must not have any personal affinity or personal connection with the dispute or the company which is in dispute or any of the stakeholders in dispute. And of course, impartiality means he must possess the quality to adjudicate the dispute without being influenced by either of the parties. So independence and impartiality is a very much necessary quality of an arbitrator. And that is what determines the manner in which an arbitrator's conduct in conducting the proceedings is going to be. Secondly, equal treatment of parties. So there is a specific section under the Arbitration and Conciliation Act, Section 18, which says the arbitrator is bound to treat both the parties equally. Of course, though the section does not venture into what is equal treatment, on a plain reading of the section, what we understand is when the arbitrator gives opportunity to one of the parties, the same opportunity is to be given to the other party. The same amount of time is to be given, the same amount of dedication is to be given, and the same level of treatment is to be given to both the parties throughout the entire proceedings. So these are 2 important qualities. Now coming to, and of course, an arbitrator should he must possess the adequate time. He must be able to devote adequate time towards the proceedings, because there is a specific time frame under the Arbitration and Conciliation Act wherein the pleadings have to be completed within 6 months from the date of commencement of the proceedings, and the arbitral award is to be passed within 12 months from the date on which the pleadings are completed. So therefore, an arbitrator should possess the adequate time to devote to the particular arbitration which he is presiding. So these 2 grounds, if not satisfied, the arbitrator can even be challenged. So these 2 are the grounds for challenge under Section 12 of the Arbitration and Conciliation Act. So let's come to the conduct of the proceeding. So now we have seen what are the qualities essential, and if these qualities are not necessary, the arbitral tribunal may be subjected to challenge under Section 12. How an arbitral proceeding is being conducted. So firstly, let's say an arbitrator is appointed. He is either appointed by the will of the parties, the consensus between the parties, or he is appointed through court, both under Section 11. In both cases, in a case where the arbitrator is appointed by consensus, both the parties, they send letters of reference to the arbitrator. The arbitrator enters upon reference, and he sends a notice of reference along with the disclosure under section 12. In a court-appointed arbitration, the same thing happens. The court communicates to the arbitrator that he is appointed as arbitrator in so-and-so dispute. So thereafter, the arbitrator enters upon reference. He sends a notice to both the parties, calling upon them to come before him and conduct the proceedings. Along with that, the arbitrator would be sending a disclosure under section 12 of the Arbitration and Conciliation Act. It is a disclosure which is present in the schedule to the Act. So this disclosure will be consisting of the number of ongoing arbitrations of the arbitrator, whether the arbitrator has any reason to believe that there is a justifiable ground about his independence or impartiality, whether he has any prior connection with either of the parties, whether he has been a consultant or an arbitrator or an advocate for the either of the parties concerned in any prior proceedings. All these details are given in the disclosure. So the disclosure is sent. After receiving the notice of reference and the disclosure, the parties come before the arbitrator on the preliminary date fixed for the hearing. So what happens is, on the first day of the preliminary hearing, a procedural order is passed. So this procedural order means it is the manner in which, or it is the timeline in which the entire arbitral proceeding is going to be conducted. So this procedural order would basically comprise of the language in which the arbitration is going to be conducted, the manner in which the pleadings are going to be compiled, the timeline in which the date for filing of a claim statement, the date for filing a reply to that, the manner in which evidence is going to be adduced, whether it is going to be oral or only documentary evidences, the manner in which communication between the parties is going to happen, whether it is all through internet mode or whether it is going to be by way of physical exchange of communications, and all these things. So this procedural order, which is passed in a preliminary hearing, is going to determine the entire arbitral proceedings, because you compile the entire procedural aspect in the form of an order. So this procedural order is passed. In the procedural order, the arbitrator would give a timeline with the consent of course, this procedural order is passed only with the consent of the parties. So the arbitrator puts forth his suggestions regarding the procedure, and if at all both the parties consent to that, accordingly the procedural order is drafted. So this procedural order would have a timeline. So accordingly, the timeline is going to be followed. Initially, the claimant is going to file their claim statement before the arbitrator, followed by along with the supporting documents, followed by a statement of defense from the respondent, and if necessary, a rejoinder to the statement of defense by the claimant, followed by a sur-rejoinder to the rejoinder filed by the claimant. So with this, pleadings come to an end. So this entire exercise of completion of pleadings is going to be conducted within 6 months from the date on which the arbitrator entered upon reference. So we have completed the first part of the proceeding. So till this part, the role of the arbitrator is quite limited, because his role is only to receive what is being filed and communicate that so and so is filed, and it is taken on record. The next part is where the parties adduce evidence and they go for appreciation of evidence and arguments. So immediately after the pleadings are completed, the arbitrator proceeds to frame issues, receive an admission and denial of documents from either of the parties. So both the parties submit their admission and denial along with draft issues. Based on that, issues are framed. And thereafter, the arbitrator calls upon if at all the parties want to let in oral evidence, the arbitrator calls upon the parties to let in oral evidence. So of course, like that of a civil court, evidence by way of an affidavit is permissible in arbitration. It is, of course, again, it is by the consensus of the parties. So here, this is the most important part. In this part, the arbitrator's role, in fact, the arbitrator is the person who is going to be conducting the entire show in this part of the arbitral proceedings. Because the stage of evidence is a very crucial stage in any trial. As we know, civil courts, even civil courts, the court which is adjudicating the dispute will not be the court which takes the evidence in most of the cases. Of course, in our practice, we see in municipal courts, the court which is adjudicating the dispute itself takes evidence. Whereas, if you see in a High Court of Judicature or in a court or in a district court, particularly in the state of Tamil Nadu, we have separate courts for the purpose of taking evidence alone. In the High Court, we have a master who's examining the witnesses, and in case of a district court, we have ad hoc courts which are constituted specifically for the purpose of examining witness evidences. So here I say, the reason I say that the arbitrator's role is very wide is because he has to take the evidence and he is not bound by the Indian Evidence Act. So the arbitrator would be having a tough time when either of the parties are going to dispute on the evidence. Like, for example, let us take section 65B of the Evidence Act. Now it is mandatory that any electronic evidence which is produced in a trial should be accompanied by a certificate under section 65B of the Indian Evidence Act. And the Supreme Court has also very recently held that without 65B, any electronic evidence will not have even the evidentiary value of a secondary evidence. Now, coming to an arbitration, let's assume you want to produce an email before the arbitrator. And though the Arbitration Act says it is not bound by the Indian Evidence Act, the principles of the Code of Civil Procedure and the principles of the Indian Evidence Act would still apply to an arbitration. Now, let's assume one of the parties want to mark an email generated from a computer and a printout of an email. This is a piece of a secondary evidence. And let's assume the other side, the opponent, disputes to mark this document by stating it is not accompanied by a certificate under section 65. What would the arbitrator do? Would the arbitrator mark the document despite the objection? Or would the arbitrator refrain from marking, saying it is prohibited under section 65B of the Indian Evidence Act? Again, it is completely the discretion of the arbitrator. The arbitrator should have, here is where the procedural order comes into force. So at the time of deciding the procedure, the party should have decided the manner in which evidence is going to be adduced. Though it is stated that Evidence Act does not bind the proceedings, the arbitrator and the parties are still free to choose that let us examine witnesses on the basis of Indian Evidence Act. So here it is completely the discretion of the arbitral tribunal. So here, that is the reason I said it would be a challenging, this would be the most challenging part of an arbitral proceeding. So likewise in a court, both the evidence of both the parties are examined. And after examination of witnesses, the matter gets posted for arguments. After completion of arguments, then comes the most important role of writing an award. So this is the adjudicatory role of the arbitrator. Now the arbitrator is going to look into the evidence before him. He is going to appreciate the evidence. He is going to compile the pleadings. And based on the material before him, he is going to pass an award. So this is the manner in which an arbitration proceeding would be conducted. Of course, this is similar to that of a civil court. How the manner in which in a civil court a plaint is presented, a written statement is called for, then we go for the framing of issues, trial, arguments, followed by judgment. The same method is followed here, but what I said right now is the procedure which is predominantly followed. So now coming back to where I started, each arbitrator would have his own way of conducting the proceedings. But no arbitrator can derail or go away from any of these proceedings. Of course, there is a concept of fast track procedure under the arbitration and under section 29B, if I'm not wrong. There is a fast track procedure wherein the parties can even decide that let us complete the pleadings, and based on documents before the tribunal, based on final arguments, let the matter be adjudicated. There is no oral evidence, only based on document evidence. There is a concept of documentary or document only arbitration, wherein only documents are submitted before the tribunal. There are not even oral pleadings, only written pleadings followed by documents, and the tribunal itself decides the matter on merits based on documents before. So these are, procedural flexibilities which the parties are entitled to, but each and every stage which I explained right now, starting from pleadings to evidence, arguments, and writing of award, is what is predominantly followed in most of the ad hoc and institutional arbitrations in India, and mostly it is in every part of the world. So this is how an arbitration proceeding is conducted. And with regard to behavior, as I already said, there is a famous, there is a settled law that justice should not only be done, it should seem to be done. It means it is not enough if you are going to deliver justice to the parties. Justice must be seem to be done. Even an outsider who views the proceedings must feel that justice is being done. The similar thing applies to an arbitrator's behavior. You may be impartial. I'm saying this because you're all prospective arbitrators in the coming days, and when you have a prospective appointment before you, the manner in which you are going to adjudicate is alone not going to determine the manner of your behavior with the parties, and your behavior in the proceedings would definitely determine your future in the arbitration. So likewise, like the quote I just said, impartiality and independence, it is not just necessary if you are independent and impartial. It must seem that you are independent and impartial. So how it can be done is, though proceedings are confidential, you need to be clear cut on the equal treatment of the parties. Record everything in the proceedings. Whatever transpired in the arbitral proceedings on a particular day should be reciprocated in the proceedings or the minutes of the meeting. Record everything in the form of a procedural order. Even an adjournment sought, let it be by way of an email or let it be by way of a memo which is taken on record, so that on a future date, parties may not take a plea that the arbitrator's behavior was not right or the arbitrator's conduct was not right, and therefore let that not become a ground for challenging the award. So I think I've shared my experience of how an arbitration proceeding is conducted, and what is the role of an arbitrator in conducting the proceedings. So maybe this could be of help to you in the near future when you are presiding as arbitrators or you're a part of an arbitral tribunal, or even when you're going to be appointed as a tribunal secretary, appointing assisting an arbitral tribunal. This could be of at least some use. So yeah, with that I would like to conclude my session, and now over to CP. Yes.
So on behalf of KFCRI, I just want to take this moment to thank our guest speakers, Mr. Shahrukh Kumar and Ms. Samina Syed, to sharing their experience with us today. And Samina Syed's insight on topic of emergency arbitration and Shahrukh Bro's insight on the conduct of arbitral proceeding. I think it's going to be it was an interesting seminar to get in. And I hope the audience have learned a lot from this presentation. We are grateful for your time and efforts in preparing this webinar. Thanks a lot, speakers. And it is up to the participants now. You can ask questions with the speakers. If you have any clarifications on the topic which I've dealt today, the participants can go ahead.
I think probably Deva Sigamani sir is having some technical issue, because he'll definitely be having some questions to be asked. But if he is quiet, then I think he is having some technical issues.
So you have to unmute, sir.
In emergency arbitration, who will apply the first? What basis he applied for the emergency arbitration?
Sir, as I mentioned before, any party that needs an interim relief can apply to the institution to which they have already conducting their arbitration procedure in, to appoint an emergency arbitrator and resolve their pleadings before them. So any party who is in an urgent and immediate need to get an relief, it's not only pertaining to a claimant or a respondent in a dispute, but any party who is in a need for an emergency measure can apply and can get a resolution out of it.
Is it any limitation period?
Basically, emergency arbitration can be resorted before the constitution of an actual arbitration tribunal. So from the period of a request to the arbitration, that is to the institution, until when an actual arbitration tribunal is constitution, there is a period, and after which you can apply to the actual arbitration tribunal itself.
Thank you.
For
Thanks.
It's a pleasure. Thank you so much.
Does anyone have questions on the conduct of arbitral proceedings? Okay, then I take it as, yeah.
I have a doubt, sir.
Yeah,
So,
please go ahead.
if the parties agree to a specific procedure to conduct arbitration proceedings,
Yes.
Sir?
Yes, yes.
and the arbitrator, for example, if the arbitrator is not okay with such procedure, who has the final say to that procedure? Whether it's arbitrators?
No, it is completely the party autonomy. So we have, the most important feature of arbitration in itself is party autonomy. So when both the parties want to agree on a procedure, and if the arbitrator doesn't want to go with that procedure, then it is the arbitrator, then the parties version stand there. So the arbitrator cannot go beyond what the parties agree.
Okay, sir. And in other case, if the parties themselves don't agree with the same procedure?
Yes. So if the parties themselves don't have a procedure to be agreed, then the arbitrator will decide on the procedure. And of course, it is deemed that the parties accept to the procedure. That is why I mentioned about the importance of a procedural order. So in a procedural order, even if the parties are not able to come to a consensus on the procedure to be followed, the arbitrator is going to suggest a procedure and the parties are going to abide by that. So once the parties have given their consent to the procedure which is suggested by the arbitrator, then they cannot go beyond that. So in that case, in any case, it is the parties, the consent of the parties, the procedure is going to be fixed. In case the parties are not able to come on a consensus, then the tribunal would suggest, which again would go through the consensus of the parties.
Okay, sir. Thank you, sir.
Sir?
Yes, sir.
While conducting the arbitrations,
Yes, sir.
one plaintiff or dependent deceased, after the LRS has a right to conduct the arbitration continuously or not, sir?
Of course, sir, because in civil right, in civil law, the right does not die with the person. So the right survives. But the question is whether an arbitrator has the right to implead the legal heirs. So it cannot be. So once a party to the proceeding has deceased, you cannot invoke Order 22, Rule 3 of CPC before an arbitrator. The matter again, if in such a case, then the legal heirs of the party, then they again have to initiate afresh arbitration proceedings and they have to contest their rights.
Thanks.
Because an arbitrator cannot assume the role of a court in impleading the legal heirs of a deceased person.
Thanks. Oh, one more question. Arbitration finalists the award.
Yes.
At the time when dependent of mandate became insolvency,
Yes, sir.
how can I get the amount from this party?
It is the same.
What is the procedure?
It is the same procedure as that of a decree of a civil court, sir. So we obtain a decree from a civil court and the person is insolvent. So we go before the execution court. Once he is insolvent, his properties are attached, or if it is a company which goes into liquidation, then whatever we receive from the liquidator, the same procedure is followed here. Just because it is an arbitral award, the procedure does not change. The arbitral award is considered as a decree of a civil court. It is subject to execution proceedings, and based on the execution proceedings, you receive your whatever you are entitled to. But the difference is, again, here this is not a decree of a civil court, whereas it is an arbitral award. That is the difference between what is in a civil court and an arbitration. But the execution proceedings and the manner in which it is going to be recovered is going to be the same.
Thanks, sir.
With this, we conclude the questioning sessions. Now I invite Mr. V. Inpovision, International Arbitrator and a Managing Partner at KFCRI, for giving closing remarks.
Thank you. Thank you for the participants of 10th AAP, successful participants of 10th AAP joining this brainstorming session on the topics emergency arbitration as well as the procedures in the perspective of an arbitrator. I take this opportunity to welcome the accredited members who have completed the 10th AAP, and very well, I'm happy to make them part of this ADR community, what we are intelligent upon and what we are focusing in a long-term perspective, how to promote this ADR practitioners. And as a part of KFCRI for another 1 year, most of you in the minimum 1 year, you're going to be with us, starting from 1st April 2023. Your contribution, either by way of writing articles, participating in our arbitration sessions, doing and getting involved in the research, what is going to be facilitated by KFCRI, along with that, getting involved in some interesting arbitration cases. It would be a wonderful period coming forward, and with our delightful team of managing committee members like Mr. Shahrukh Kumar, Mr. Svetan, Mr. Shanmudev, and other associates like Ms. Samina Syed, Mr. Sipi Vish, Mr. Kirtivasan, Ms. Amina, many more who are part of KFCRI promoting this wonderful concept of ADR. We, KFCRI, being part of Kowais Foundation, which has a brainstorming idea of reaching this ADR procedures and the process to the grassroots level, very important. That is the interesting and innovative idea of KFCRI and Kowais Foundation advising on that line. We are thankful once again for all of you who have opted to get the accreditation from KFCRI and who are going to have a long journey with us, at least for this first year of 23-24, starting from 1st April. And your support is always required, and your participation also is very important and significant for us to take this message to the concerned people. The stakeholders are quite awaiting our services. The huge market is available in the commercial sense, and it is always very important for litigants to be properly guided. And KFCRI is going to take this task along with the existing members and the present members out of the 10th AAP. We will have a good year ahead, and we will have the mantra of ADR as such, and don't litigate. Thank you. thank you for participation and spending a valuable time, 1 hour time on a weekend, that too on a second Saturday. And thanks for our team members for facilitating this wonderful session, which is beginning for the members of 10th AAP. Thank you.
And housekeeping rule, we sent out a link asking you to fill it in order to send your certificates via courier. If any of you haven't done it, we kindly request you to do it. Thank you so much.